Hello everyone and welcome back to our channel. My name is Malescu and I am the owner of Malescu Law, a law firm based in Miami, Florida, specializing in business, corporate and US immigration. We can assist you with all your immigration needs regardless of where you are currently located or where you plan to go in the United States. But before we get started, please subscribe to our channel by clicking the bell button or the subscribe button. Today we are going to speak about a complex E-2 investor visa case that we recently finished, and by finished I mean that the E-2 visa was successfully approved. Now, not every E-2 visa case is straightforward, such as buying an E-2 business or starting up an E-2 business with cash that you have saved or you have inherited or somebody has donated to you. Not all cases are like this. There are a number of cases, and throughout time we've seen many cases that are complex. They're E-2 visa cases, but they're complex, and the complexity arises from a variety of issues, such as, for example, when the investor does not have the education or the background for the business that they plan to do in the United States, or the investor has had in the past visa denials, or if they were Canadian investors, maybe they have withdrawn their application for admission to the United States in the past, and there is a record of that encounter with CBP. Other times, complex issues arise from the investment in itself. What is being invested in the US business? At times, investors don't only invest cash. They can invest, for example, equipment or machinery that they import into the United States, or they can invest an asset class that is not traditional, such as, for example, investing crypto in a US business, and we have a case like that in the past. You can check our other videos. And other times you can also have complex E-2 investor visa cases when, for example, the money that is being invested is not over $50,000. So you have an investor that maybe is investing $30,000 or $40,000. Those cases are complex. And other times where you can have complexity is also when the investor is buying into an existing business, a business that, let's say, at times is very successful, and then you have to look at their investment as well, or when they are investing intellectual property as opposed to cash, machinery and any other type of equipment. In our E-2 investor visa case, the complexity was twofold, or even threefold if you want. First, the investor invested software, so intellectual property, in a new US business, and this intellectual property, this software, was actually developed 3 years prior under a different company. What has happened in this case is that the investor has obtained an E-2 visa in the past together with a business partner, and they have gotten into a dispute, and the other business partner has managed to disclose or even transmit part of the intellectual property to part of the software that was being developed to a third party, an outside contractor, and out of this dispute the investor wanted to take their software that they developed and put it in a new company and have full control over the implementation of the software. So this was one of the challenges, the fact that in the E-2 case, in the new E-2 visa case that we presented, the investor truly invested software as intellectual property, and we had to show that the software intellectual property was a substantial investment in the E-2 business, and this software was developed 3 years prior to application. The second layer of complexity was that the investor obtained their initial E-2 visa on the Italian passport, but now wanted to transition the new application to their UK passport in order to align with the family's UK nationality. So in this case, while the initial E-2 visa was on the Italian passport, we had to transition and have the new E-2 visa be issued on the UK passport, which, if you know anything about the E-2 investor visas, this sounds much easier said than done. And the third layer of complexity, if you will, is the fact that the investor was applying at a different US consulate than their initial E-2 investor visa. So in this case, we applied at the US consulate in Canada, in Toronto, Canada, while their initial E-2 visa was obtained in Europe. And just to make the case even more complex, we did receive a request for further evidence, which is not unusual in complex cases. And this request for further evidence really questioned the investment in itself. It questioned, one, that the investment was irrevocably committed to the US business. So in other words, that the software, the intellectual property, was irrevocably committed to the US business. And also, two, the consulate requested proof for the development of the software. So what was our strategy? In this case, where the investor was going through a business dispute and was trying to protect their intellectual property, the software that they developed, from their former business partner, and they were confused what exactly is it that they are investing in the new E-2 enterprise, and the company was being ran remotely, we had to come up with a creative strategy to address this complex E-2 visa case. And we have done so by obtaining an IP valuation of the already developed software and contributing this software to the new enterprise. We basically based an entire case strategy for the investment on this software valuation and contributing this software to the company. Now, the software was essential to this business because the business is an educational software company. So it is not as if we took a software that was tangentially related to the business. No, the software was the core of the business, and we based the entire strategy on contributing this software to the business. And then we also took into consideration the fact that there was a change in enterprises. So the initial E-2 visa was issued for one enterprise, but now, and we were moving away from that initial enterprise because of the business dispute to another enterprise and applying for the E-2 with this new enterprise, despite the fact again that the software was initially created for the first E-2 business. And after that, we also received that request for further evidence from the US Consulate in Toronto that was questioning the investment, the irrevocable commitment of the software to the US business, and also the cost of development of this software, because the software was initially developed in the years prior and through a foreign entity. And finally, we also had to adjust the strategy based on the investor's decision not to apply with the Italian passport for a renewal of an E-2 visa, but instead to apply for a new E-2 visa on a completely different passport, on the UK passport at the US Consulate in Canada, a country where the investor was not a resident of. So the investor was not a resident of Canada and was not a resident of the United Kingdom. The key takeaways in this case are: 1. Third country processing. This case involved processing the E-2 visas at the US Consulate in Canada for UK national, despite the fact that the investor and their family members were not residing in Canada. 2. Overcoming a request for further evidence. As already discussed, we received a request for further evidence from the US Consulate in Canada. We were successful in our approach and documentation, and the E-2 visa was approved for the investor and their family members for 5 years, the maximum allowed under the treaty between the United Kingdom and the United States. And finally, third, the investment, software intellectual property as investment. The entire investment in this case for the E-2 visa purposes was a software, so intellectual property that was developed in the past and contributed to the US entity, for which we obtained a software valuation. Now, we did obtain a software valuation because also the software, the US business was operating, had employees, had contractors, and had clients. And now a short overview of E-2 visas. E-2 visas are available to citizens of E-2 treaty countries that invest a substantial amount in a US business, whether by starting a US business, purchasing a US business or a franchise, or investing in an already existing business by purchasing a certain percentage of that business. Now, there's no minimum of investment required when we speak about the E-2 visas, but in general, you should expect to invest above $50,000, although there are successful cases with less than $50,000. The investment really depends, and whether that investment is substantial or not really depends on the nature of the business, the location of the business, and also the stage of that business. So whether you are investing in a startup or you are investing in an existing business, but maybe that business is not doing so well. So all of these issues we take into consideration when determining whether your investment is substantial or not. With the E-2 visa, you can bring your spouse and children to the United States. They also receive E-2 visas, and your spouse and children do not need to have the same E-2 treaty nationality as you, the principal investor. The principal investor can also bring managers and executives and individuals that have essential knowledge for the US business, but they must be from the same E-2 treaty country. You can renew the E-2 visas indefinitely as long as your business is successful, and generally you can obtain an E-2 visa based on your current treaty country and the reciprocity table, but it can be for a maximum of 5 years if your treaty permits 5 years E-2 visa. This is all for today. Thank you so much for watching. Please subscribe to our channel, and if you need to get in touch with us, you have our contact information in this video and below this video. We will see you soon. Bye.